You have a script, but the industry doesn't know your name. And if you want to use the characters the world already loves, you'll find their owners have budgets and legal teams you can't possibly match. But billion-dollar pieces of pop culture history have been abandoned. The companies that built them simply failed to do their paperwork, leaving the characters in the public domain. This flowchart tracks the mechanics of the 1909 Copyright Act. Under these rules, ownership wasn't a right, it was a favor you had to earn. You needed a specific copyright symbol, a precise page placement, and a manual renewal exactly 28 years later. If a publisher missed a single deadline or printed the notice on the wrong page, the entire mechanism failed. The work immediately became public property. While the 1976 Copyright Act eventually made protection automatic from the moment you create something, those rules were not retroactive. Every failure to follow the machine's rules before 1978 is permanent. The law cannot reverse these administrative errors. Because these characters were never properly secured, they remain available for anyone to use. George A. Romero learned this through Night of the Living Dead. When the distributor changed the title at the last minute, they forgot to put the copyright symbol on the new title card. That single omission stripped Romero of his ownership the day the film reached theaters. Rankin Bass made a similar error with Rudolph the Red-Nosed Reindeer. They printed the copyright year in Roman numerals as MCLXIV, or 1164. Because the law calculates the 28-year term from the printed date, the copyright technically expired in the year 1192. Charlton Comics followed a similar path. Instead of the required copyright symbols, they printed legally meaningless text on the second interior page, rather than the title page. These errors effectively open-sourced early versions of superheroes like Peacemaker. To use these characters legally, you have to distinguish between the design and the brand. A character's visual appearance is governed by copyright, which expires. Their name is often a trademark, which can be renewed indefinitely. You can put the exact visual design of that 1964 reindeer on your screen today, but if you call him Rudolph on your poster, you are infringing on a trademark. Market him under a different name, and the studio has no legal grounds to stop you. Some films entered the public domain by accident, but remained under a different kind of control. Republic Pictures failed to renew the film footage for It's a Wonderful Life, which allowed TV stations to broadcast it for free for decades. This shows why the film is still difficult to adapt. While the footage is free, showing it can still infringe on the separately copyrighted short story and the separately registered musical score. If the underlying materials were renewed, the film remains restricted. This is the timeline rule. In the case of Archie Comics, the publisher failed to renew the first 71 issues. This means you can legally use those characters today, provided you base your script strictly on the original 1941 versions. If you accidentally borrow a character trait or a visual update introduced in a later, properly renewed issue, you lose your legal protection. Pulp magazines operated under a different rule set. While publishers registered the magazine itself, the right to renew individual stories belonged solely to the author. This created a crisis if an author died before their 28-year renewal window opened. In those cases, only the legal heirs could file the paperwork. Because the heirs for writers like H.P. Lovecraft and Robert E. Howard didn't file, foundational elements of the Cthulhu mythos and the original Conan stories are now public property. These combined bureaucratic failures allow you to do what the major studios cannot. You can now legally put a 1940s superhero and a 1920s cosmic horror together into a single scene. No studio note and no license fee can stop you from filming that interaction tomorrow. When you understand what has been abandoned, the scale of what you can build is massive. Corporations still attempt to use aggressive trademark claims to protect these characters, hoping to scare independent creators away from material that is legally free to use. But the Supreme Court addressed this directly. In 2003, they issued a unanimous ruling in the case of Dastar v. 20th Century Fox. Writing for the court, Justice Antonin Scalia argued that trademark law cannot be used to block the use of public domain works. To do so, he said, would create a mutant copyright law that subverts the Constitution. This ruling gives you the right to adapt and sell these abandoned works without asking for permission or giving the original studio any credit. Before you shoot, follow two mandates. First, audit every underlying right to ensure the story wasn't adapted from a separately copyrighted novel. Second, pull the physical records from the U.S. Copyright Office to verify the lapse. Keep a physical folder of those records. A prepared paper trail is often enough to diffuse a nuisance lawsuit before it ever reaches a courtroom. A century of paperwork errors has left the cultural equity of the major studios sitting in the public domain. The Supreme Court confirmed that it belongs to you. Take these rules and build something the studios cannot touch.